As a member who is a tenant and a renter, I am happy to take the call on this bill. This bill will update and modernise the Residential Tenancies Act 1986, and the Greens will be voting in support of this bill, but we lament the missed opportunity to increase rights for the more than 1 million tenants who reside in New Zealand. We support many of the minor changes in this bill to clarify existing law, for example, clarifying provisions relating to address for service of documents relating to the tenancy, clarifying that landlords must give a reason for terminating a periodic tenancy with less than 90 days notice, clarifying that an agreement for sale and purchase must be unconditional before a landlord can give 42 days notice, requiring a landlord who is overseas for more than 21 days to appoint an agent. As the youngest member in this House, born only 5 years before the Residential Tenancies Act first came into effect, I acknowledge that New Zealand's housing has changed substantially over that time. Since 1986, the proportion of New Zealanders renting their homes has gone up, fewer young people are flatting away from home, and more older people with families and children are renting. Home ownership rates have declined to 67% from a high of 74% in 1991 and are predicted to drop further still to 62% by 2016. New Zealand has around 450,000 rental properties housing a third of our population. According to the 2006 census, 1 in 3 households, that's 33%, do not own the house they lived in, up from 32% in 2001 and 29% in 1996. More and more Kiwis are renting because for many, purchasing a house is a distant and impossible dream. Housing affordability is a major issue in New Zealand, with close to 1 in 3 New Zealanders now spending 30% or more of their disposable income on housing. Demography's 2009 International Housing Affordability Survey found that the median house price in New Zealand is 5.7 times the median household income, ranking New Zealand in the category of severely unaffordable, with only Australia worse than the world at 6.0. The bright side, of course, is at least we're catching up with Australia in one respect. As I pointed out to the House last night in the infrastructure bill debate, it's an especially pertinent issue for people of my generation. People of my generation see home ownership as an almost impossible dream. It's a struggle for people who come out of university or other tertiary education encumbered by debt. They're conscious they're entering a housing market that's grown rapidly over the last decade, mostly to the benefit of baby boomers or those already on the property ladder, and that hasn't been slowed by sensible moves, such as a capital gains tax not on the family home, or reviewing the tax rules around loss attributing qualifying companies, LAQCs. LAQCs allow people to offset their losses on the investment properties against personal income tax. This means that young people trying to get onto the housing market are effectively subsidising the tax offsets of those buying investment properties using LAQCs. This is both wrong and pernicious. We can't rely on the recession, as Moana pointed out, to make housing more affordable. We need to be more proactive as legislators and regulators. The trend towards less affordable housing will see the numbers of tenants increase, so make the changes discussed here today in this House as relevant and as important as ever. This bill is an important amendment to update the original 1986 legislation. It's important we strike the right balance between the rights of landlords and the rights of tenants. I'd like to take a few minutes to look at a few issues the Greens have with this bill in particular. I'd like to look at the termination of tenancy for boarding house tenants, the issue of letting fees, the unfortunate oversight of not addressing the issue of termination of a residential tenancy following the death of the tenant, legal representation issues, and exemption for people who reside in camping grounds and backpackers and other such places. Looking first at the termination of boarding houses. The security of tenure issues for boarding house residents that we had concerns about in the earlier stages have been improved somewhat by the Select Committee, though not to the extent we would have liked to have seen. It's still better, however, than the current situation where boarding house residents have no security of tenure whatsoever. New Section 66U of Clause 47 sets out when landlords of boarding houses may terminate a tenancy either immediately or on 48 hours notice, 14 days notice or 28 days notice. It's good that the Select Committee recommended amending the criteria and allowing 10 days consecutive notice that rent is in arrears before giving a tenant 48 hours notice of termination, where the tenant's rent is more than 7 days in arrears. Tenants can face legitimate reasons for being in arrears, often through no fault of their own. Many boarding house tenants receive benefits from the state, and as Sue Bradford reported in the first reading speech, often this is because of problems caused by work and income, rather than the beneficiary him or herself, and such issues do take time to work out. For those boarding house tenants who are also mental health clients, we concur Labour's call for an expectation that proprietors would take the opportunity to refer such individuals to appropriate mental health services if an eviction is being contemplated. And at least we support the provision of a list of services in each area which should be made available to the proprietors of boarding houses so they may refer such people before the eviction is effected. Looking at letting fees, this bill proposes to remedy the anomaly of real estate agents being able to charge letting fees while property management companies cannot, by allowing both to do so. Letting fees on top of a bond, rent in advance, and other moving costs can be a significant barrier to beneficiaries, to students, and other people on low incomes needing accommodation. The Green Party supports prohibiting letting fees, full stop. Provisions in the bill regarding the termination of a residential tenancy following the death of the tenant do nothing to improve the current situation where a caregiving relative is suddenly evicted from their home following the death of the family member for whom they've been caring. Relatives of the tenant living with the tenant should at least have some protection of tenure when the tenant dies. This was one of our original concerns about the bill, and it is unfortunate it has not been addressed properly by the Select Committee. The bill continues and increases the continues from $3,000 to $6,000 the monetary threshold for the right to legal representation in the tenancy tribunal. This continues the current unfair provision that permit a corporate landlord to be otherwise represented by an experienced tenancy manager, while the tenant, who often knows little about tenancy law and may well have English as a second language, is forced to represent him or herself. This places many tenants at an unfair disadvantage in tenancy tribunal proceedings, and an example where the bill could, but fails to strike a fairer balance. There is a provision, section 63(3)(b), that permits representation where there is significant disparity between the parties affecting their ability to represent their respective cases. But the problem with it is that the disparity in the ability of the parties to represent their cases may not become apparent until a case has been partly heard. The Green Party was advised by the Tenants Protection Association about this a while ago, and we were told that adjudicators almost never invite a tenant who is disadvantaged in that regard to obtain representation. This was one of our concerns with the original bill and is also noted in Labour's minority report. This is probably also a good time to raise the excellent and also lacking provision in this bill made by the Citizens Advice Bureau, who recommended that plain English statements of tenant rights as part of all tenancy agreements and displayed prominently in boarding houses be adopted. My last point, Mr. Speaker, is that the homelessness survey is due to come out in June, and I predict, based on Australian similarities, which will see between 20 and 30,000 Kiwis officially classed as homeless. Many of these people reside in non-traditional housing forms such as caravan grounds and backpackers. This bill fails to address the fact of life in 21st century New Zealand that many Kiwis do not live under stable tenancy criteria. The Citizens Advice Bureau gave some terrible examples where those not formal tenants have been abused by the system. I concur with what Moana Maki is saying, that we do need a Select Committee inquiry into homelessness. This already occurs in countries such as England and Wales and many states of Australia, and is a good example of where a much-needing updating of this 1980s Act does not go far enough to reflect the facts on the ground in the real world. So in summary, Mr. Speaker, our main criticisms of the bill at introduction were over issues this bill doesn't address adequately. However, following the Select Committee changes, some positive and some negative, we still think it remains the case for the Green Party on the balance of evidence to support this bill. Kia ora.